One of the most common interactions you might have with the police is when you're being pulled over in your motor vehicle on the side of the road for traffic infraction.
Motorcycle rider, pull forward until I tell you to stop.
To the average citizen, one of the most visible law enforcement activities is the vehicle stop.
Turn your engine off and step to the curb.
They see something like this happen every day. An officer puts on his emergency lights, follows the driver to the curb, gives him a ticket, and sends him on his way.
Now, in New York versus Belton, the Supreme Court in 1981 said that officers may search the passenger compartment of the vehicle after making a lawful arrest of the occupant. This is so-called search incident to a lawful arrest exception under the Fourth Amendment, meaning that officers don't need to have a warrant to search that passenger compartment as long as the arrest is lawful. But what about the situation where the officers make the first contact with the occupant well after that individual has already left the vehicle? That is the question we're going to answer today. And before we go on, I want to thank you for watching me here on YouTube. If you're new to the Lost Stash channel, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And finally, if you want to support this channel, consider going to loststash.com and check out some of the merch, including the Do Not Arrest This Person t-shirts. Thanks for watching.
Quick message from Lost Stash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Belton discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Lost Stash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Lost Stash YouTube page. That's LAWSTACHE.
Today we're discussing Thornton versus United States, a Supreme Court case from 2004. But first, let me give you some factual background. Police officer was driving in Virginia in an unmarked vehicle, but wearing a uniform. He pulled alongside Mr. Thornton, who then began to slow down, as though he didn't want to drive next to this police officer. Now, the officer believed that was suspicious, and he thought that Mr. Thornton recognized that this was in fact a police vehicle. Now, I always find it interesting that if Mr. Thornton would have sped up, that he would get a speeding ticket, but anytime an individual matches the speed or slows down, well, that's also suspicious according to law enforcement. It is particularly interesting in situations like this one, where the law enforcement is driving an unmarked undercover vehicle. But that's beside the point. Here the officer thought it was suspicious. He pulled back and then saw the license tags on this vehicle. He put the information into his computer system and figured out that the license plate matched a 1982 Chevy and not the Lincoln Town Car that Mr. Thornton was driving in that moment. By the time he was trying to catch up to Mr. Thornton has already pulled into a parking lot, parked his vehicle, and got out of it. The officer then pulled into the parking lot, parked his undercover vehicle, and approached Mr. Thornton, who was again standing already outside of his vehicle. The officer then asked Mr. Thornton for a driver's license, and he explained the reason why they had the interaction. The officer told him that the tags on the car did not match. At this point, the officer then asked Mr. Thornton if he had any drugs or weapons in the car or on him. Mr. Thornton said no. The officer then asked if it would be okay for him to pat down Mr. Thornton, and Mr. Thornton agreed. Now, a quick side note, never consent to searches. If the officers have a reason to pat you down or search you, they will do it anyway. No need for your help. No need to consent to searches. So again, never consent to searches. Here, Mr. Thornton agreed to a pat down, and during this pat down, the officer felt a bulge through the clothing. He then asked Mr. Thornton again if he had any weapons or drugs on him, and this time Mr. Thornton said that he did have drugs on him. The officer went into the pocket and retrieved 3 bags of narcotics, marijuana and crack cocaine. At this point, Mr. Thornton was arrested, handcuffed, placed in the patrol vehicle, and then the officer went into Mr. Thornton's vehicle and searched it. There he found a 9mm handgun. Mr. Thornton was charged with drug possession, distribution, and a slew of other drug-related charges, but he was also charged under 922G as felon in possession of a firearm. Mr. Thornton says that the search of the vehicle was in violation of his Fourth Amendment rights. Now remember, the Fourth Amendment protects against unreasonable searches and seizures, meaning that officers usually need to have a warrant before they search you as your person or any of your property. And here, the officer did not have a warrant, but he's relying on what's called search incident to a lawful arrest. A quick plug, a few years ago I published a series of videos titled Vehicular Searches Without a Warrant, where I've discussed all the exceptions to the warrant requirement under the Fourth Amendment as they relate to motor vehicles. After you watch this video, I ask you to go back and watch that playlist. It will explain all the exceptions, and this way you'll understand it a little bit better. Now today, we're focusing on search incident to a lawful arrest. Now this exception did not originate in a motor vehicle context. Instead, in Chamel versus California, a 1969 case where the arrestee was arrested in his home, the Supreme Court had described the scope of a search incident to a lawful arrest as the person of the arrestee and the area immediately surrounding him. This rule was justified by the need to remove any weapons the arrestee might seek to use to resist arrest or to escape, and the need to prevent the concealment or destruction of evidence. Then in New York versus Belton in 1981, the Supreme Court held that when a police officer has made a lawful custodial arrest of an occupant of an automobile, the Fourth Amendment allows the officer to search the passenger compartment of that vehicle as a contemporaneous incident of arrest. But here we're dealing with a situation where the individual is already out of the vehicle by the time the interaction with the police begins. But the court says that in all relevant aspects, whether the individual is outside of the vehicle or inside the vehicle, the same concerns about the officer's safety and the destruction of evidence exists. The court says that even if the individual is outside of the vehicle, they can still lunge into the vehicle to retrieve a weapon. The court does, however, acknowledge that there might be arguments in terms of spatial and temporal relationship between the person and the vehicle. But at the end of the day, whether the person is inside or outside does not matter. So if the officers are making a lawful arrest of the occupant or quote-unquote recent occupant, they can search the motor vehicle without a warrant under this SILA or search incident to a lawful arrest exception. I hope you learned something today, and if you did, give this video a thumbs up. If you're new to the Law Stash channel, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to lawstash.com and check out some of the merch, including the Do Not Arrest This Person t-shirts. Thanks for watching, and I'll see you next Wednesday for another deep dive on another criminal case. Thanks for watching.